Hello, everybody. Welcome to Joe the Lawyer. So today I watched the Kyle Rittenhouse direct examination, his testimony. I'm going to break that down. I'm going to explain to you a little bit from a legalese point of view, and I will let you know what I think about what will happen on each charge that Mr. Rittenhouse is charged with. Now, I know the evidence is not over. I know it's not over, but it appears to me that the most important points of evidence have been testified to or presented to the jury. That's why I believe I can make this prediction from a very informed status. So thank you everybody for tuning in. I'm your host, Joe Pometto, Joe the Lawyer, a practicing criminal defense attorney. I've done multiple jury trials myself. I've been a practicing lawyer for, well, I can't believe it, 8+ years now. I do criminal defense, family law, and a little bit of injury. Whatever somebody comes to me with, I will help them. So I think I can bring a very good analysis of this case. If you like my content, please like, subscribe, comment, and share. I'm going to break down the testimony. We're not going to watch it live. You can watch it live. You can watch it before I give my analysis or after. And if you watch it before, my analysis will inform you as you're watching it, or watch it, come in, hear my opinion, and go from there. Now, the reason I think I can make this prediction now is, the case is not over. And the lawyers will put their spins on the evidence in the closing argument, in the summation, in their closing statement. However, it is always the facts that drive the case. It is always the facts, the testimony, the witnesses themselves. Lawyers have a job to do, but let me tell you, it is the witnesses that mainly drive a case. And I'm not going to sit here and tell you lawyers don't have an impact, because I feel like they can have a huge impact on the case. So what do we have here? We have Kyle Rittenhouse. And if you saw my prior videos, all right, I broke this down into three discrete interactions, right? Because Mr. Rittenhouse shot 3 people. Now, only 2 people were killed. So he can only be charged with a homicide that occurred on the basis of 2 individuals. Now, he is charged with attempted homicide. And there is the one individual, Grosskreutz, who was shot, did not die. He could potentially be convicted of intentional homicide in regards to Grosskreutz, but in regards to Rosenbaum and Huber, okay, those are the actual homicide charges. Let's look at these one by one. And this is based on the summation of the evidence. The interaction with Rosenbaum occurred first. Now, there were actually multiple videos of this that were shown to the jury. I watched all of them. None of them really changed my opinion, and none of them were inconsistent with the testimonies of one of the Commonwealth's witnesses, Mr. McGinnis, who was right there, or the testimony of Kyle Rittenhouse. Essentially, this individual, there's a row of cars there. This individual, after screaming at Rittenhouse twice, and at least one time claiming that he was going to kill him, was running at him, got into close proximity, lunged for the gun. Rittenhouse fired, I believe, I can't remember exactly, 1 to 3 shots, maybe 1 shot. I can't recall. You guys correct me on this one. Fired some shots. Mr. Rosenbaum dies. If this isn't textbook self-defense, but it's pretty darn close. If someone's lunging for a gun, you're lunging for your weapon. If they were to take your weapon away, they could use it against you. Lethal force is generally going to be authorized by, when I say this, by the appellate courts, by the Supreme Courts of every state in the 50 states. All right. Every state in the 50 states, it's going to be authorized. Somebody is grabbing your weapon, pulling your weapon away, okay, and you shoot them, causing that person's death, that's going to be self-defense. So, boom, that's Rosenbaum. And there's a couple of wrenches that we're going to throw in here, but we'll get to those. That's Rosenbaum. Then, as Rittenhouse is retreating from that interaction, many things are yelled at him. Okay. People are coming after him. This is when he has the interaction with three more individuals, including Huber and Grosskreutz. Now, Huber hit Rittenhouse in the head, neck area at least one time with his skateboard. Then there were I believe two further impacts on Rittenhouse, including a rock that hit him in the head. And then he was hit a fourth time, but the second time with the skateboard by Mr. Huber. Mr. Huber grabbed the weapon. Same thing as Rosenbaum. You're pulling a weapon away from somebody, and he fires the weapon. He shot once at Mr. Huber, and that shot happened to kill him. I believe he was also kicked in the head. Shortly after that point, the interaction occurs with Mr. Grosskreutz, where initially Mr. Grosskreutz wasn't pointing the weapon at him. According to Rittenhouse, the weapon was lowered. And here's the interesting thing about all of this. The video of the Rosenbaum interaction is not inconsistent with Rittenhouse or McGinnis's story. The photographs and video of the interaction with Grosskreutz is not inconsistent with the story. Now, if the video was very inconsistent with the story, the prosecution could cast considerable doubt on everything that Rittenhouse has to say, but that's just not the case. His story, the witnesses, McGinnis, okay, all the video, it all is consistent. It all is consistent. So there's really not that much dispute about what happened as far as the actions of the individuals involved. Now, the state of mind, the verbal things that were said, those are maybe up in the air, but I don't believe the prosecution has shown any good reason to doubt what Mr. Rittenhouse said about the threats that were made to him. So the final interaction, Grosskreutz lowers the weapon. At that point, Mr. Rittenhouse fires a single shot, hits him in the arm. I believe that there is enough there from the defense to show that Mr. Rittenhouse acted in self-defense in regards to all three of those interactions. Now, there is a doctrine in the law where if a person is viewed as an aggressor in a situation, they can lose the benefit of self-defense, or their self-defense, establishing their self-defense becomes difficult. It's a higher burden, et cetera, et cetera. So let me give you an example. Let's say that you had a gun and you're walking down the street, okay? And this is a strange hypothetical, but it will help you understand. Let's say you have a gun and you're walking down the street like this, like da, 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 and you're being reckless, but your intention is not to kill anybody. And you're walking, let's say you're walking down the street and somebody else pulls out that gun on you, okay, and then you shoot them. If you were seen as the aggressor in that situation, you can lose the benefit of self-defense. Let me give another example. That wasn't the best one. Let's say that you're in a vehicle and somebody else is in a vehicle. Oh, you know what? Let's do it. Let's have a little fun here. Okay, you're chasing someone. You're in this car, okay, and you're chasing someone. They're in the Corvette, okay? I can't remember what this car is, okay? The red car, you're in this car, and you have a gun, and you're chasing this person. You're coming after them, and let's say you don't want to shoot them, okay? But you want to scare the crap out of them. You want to point the gun at them. You want to strike fear into them. Or let's say, even better yet, let's say you want to rob them. That's even better. So, and you run this car into a dead end. This car spins around like this, and all of a sudden, this car has nowhere to go, blocked in. Okay, blocked in. And you get out of the red car, and you have a gun, and you're intending to rob that person. And this person gets out of the white car with a gun and goes to shoot at you, and boom, you shoot that person first. If you were aggressive and initiated that encounter, and there are enough facts here to show that, okay, you could lose the benefit of self-defense because you're going after this person intending to do that person harm. So that is a legal concept that could come into place here. However, That was why it was so important for the defense to establish that Kyle Rittenhouse was there he wasn't there to cause trouble. Now, people may think differently about that, but there are a lot of facts to say that he was there to help people, also to protect property. Some of his police training, his EMT training, and the fireman stuff. I know it's all like preliminary stuff. I don't know how deep that actual training is, but and that actually helps Rittenhouse because it shows he wasn't there to cause trouble, to initiate an interaction. I don't think there's enough evidence there to show that he was coming in such an aggressive manner that he should lose the benefit of a self-defense argument. I don't think those facts are there. It's usually something like, I told you, drug deal gone wrong, or a stick up gone wrong, right? Two people stick someone up in a car in order to rob them. The person in the car pulls the gun out, and the robbers shoot the person in the car. Those robbers are not going to get the benefit of self-defense, okay? It's not going to happen. They initiated and created that situation. I don't think there's enough here for Rittenhouse to lose the benefit of self-defense. So let's talk a little bit about his charges now. I'm in straight YouTube live, and I didn't hook it up with my nice little layout on Streamlabs, so I'm just going to read them to you. Let's look at some of the charges. First degree, recklessly endangering safety, use of a dangerous weapon. Okay, this is connected to Rosenbaum. Now, I think there's a little bit of chance that Rittenhouse could be convicted of that, but the self-defense defense should wipe that one out. I did think reckless endangerment. I do think there's a greater chance of him being convicted of that than there is homicide, but I do think his self-defense argument is strong enough to wipe that one out. First degree intentional homicide, use of a dangerous weapon, Anthony Huber's death. Again, I believe that the self-defense will wipe that one out. That has to be an intentional killing. Attempted first degree intentional homicide, use of a dangerous weapon. Again, there needs to be an intent there to cause homicide, even if it doesn't cause homicide. This is for the shooting in relation to Grosskreutz. I believe he will be not guilty due to self-defense. First degree, recklessly endangering safety, use of a dangerous weapon. Video shows an unknown man leaping at Rittenhouse and trying to kick him. Rittenhouse appears to fire 2 rounds at the man, but misses him. I think that self-defense will apply there. He's basically being jumped by multiple individuals. Possession of a dangerous firearm by a person up under 19. Rittenhouse was armed with an AR-style semi-automatic rifle. He was 17 years old. Wisconsin law prohibits minors from possessing firearms except for hunting. This charge is a misdemeanor punishable by up to 9 months behind bars. I don't see how he beats that one. So I do think he will be convicted of that. He had this weapon in Wisconsin, and I don't know all the intricacies of Wisconsin law, but a plain reading of that statute, he violated it. He will be convicted. He was under 18, and he had that weapon that appears to be illegal under Wisconsin law. Real quick, let's do a same time sip before I get to the rest of these, mostly because my mouth is getting dry. Raise your cup, your glass in the air. Cheers with me. It tastes better when we sip together. Thank you, everyone, for tuning in. Those who know me know I mostly drink Diet Coke and coffee. I do drink water too. Water, Diet Coke, and coffee. Those are the beverages that sustain me, for better or worse. I like my caffeine. Okay. Failure to comply with an emergency order from state or local government. Rittenhouse was charged with being out on the streets after an 8 p.m. curfew imposed by the city. A minor offense carries a fine of up to $200. The judge dismissed the charge during second week of trial after the defense argued prosecutors hadn't offered enough evidence to prove it. Well, looks like we don't have to worry about that one. So considering the list of charges, and the list of charges comes on a piece of paper, often called an information or an indictment, it is my prediction that Mr. Rittenhouse will be convicted of possession of a dangerous weapon, a misdemeanor, up to 9 months behind bars. As long as it is that's my understanding of the law, there. And I don't know if there are there could be some intricacies in Wisconsin law that I don't know about that could change my prediction there. But I believe on a plain reading, he'll be convicted of that. I do believe the self-defense will carry the day and he will be acquitted of the rest of the charges. I watched Mr. Rittenhouse's testimony throughout. It was a bit striking to me how young he truly is and appears, and that's probably done on purpose. He was clean shaven, short hair. You want your client to appear young and weak in a situation like this, in a sense. However, he was pretty well spoken and had a fairly good memory of everything that went down. Additionally, I mean, that was my, he broke down, he cried, he seemed genuine in a way that I think will impact the jurors. He did appear to be, from my eyes, to be coached, which is something that attorneys can and will do and is often done. The degree to which he was coached, I don't know, but his testimony was pretty polished. So it's fair to say that him and his attorney ran through this several times. What him and his attorney went through is called a direct examination. That's when the attorney or the side is calling a witness and eliciting the initial testimony from that witness. It's called a direct examination. The reason that matters is that lawyer is bound by certain rules, such as not asking too many leading questions, not putting the thoughts into the mind of the witness. The witness is supposed to answer open-ended questions and testify as to their memory. Now, that's a direct examination. Cross-examination is when the opposing counsel gets to ask questions. Now, the main difference between direct examination, opposing, and cross-examination is the cross-examining attorney is allowed to ask leading questions, is allowed to suggest things or attempt to put them into the head of the witness, ask yes or no questions. And the witness will answer as they may. Excuse me, the witness will answer as they may. There are other differences. A cross-examination cannot touch on facts or ideas that are outside the scope of the original direct examination. So, the direct examination here covered a little bit of his family history, why he went down there, everything that happened that day and what happened that night. So the cross-examination questions have to apply specifically to what Mr. Rittenhouse said on his direct examination. The lawyer can't ask him about, oh, did you do the same thing 6 months ago during this protest? Or, a year ago, did you accidentally fire a gun? Things like that don't play on what was talked about in the direct examination. So those are important differences that a layperson is not necessarily going to be aware of, but can often impact and certainly will impact the questions that are asked by each attorney. So you may sometimes watch a trial and say, well, why isn't the lawyer asking this? And why isn't the lawyer saying that? Well, the lawyer can't necessarily do that depending on the circumstance. And also, there might have been prior decisions by the judge that stopped the lawyer from asking certain questions. So I am going to predict, not guilty of all the charges except for possession of the weapon, a misdemeanor punishable by, I believe, up to 8 or 9 months. Likely Mr. Rittenhouse will get some form of house arrest and probation on a charge like that, especially considering he is a non-repeat offender. I was correct. I will note I was correct on my George Floyd prediction at that trial. I've predicted that Alec Baldwin will get charges against him. I'm starting to lean against that, especially from seeing an interview with the prosecutor in that county, which I want to cover in a subsequent video. Doesn't appear that she believes that charges should be filed against Alec Baldwin. But I do think that the facts are probably there. Then again, I'm not that familiar with the industry, and I'm sure actors, if you're told that a weapon is cleared and you shoot it, but I go back to the fact that you shouldn't be shooting in the direction of a human being at any time whatsoever. And there should be a degree of duty on that individual. Regardless, you've heard my prediction: acquitted, not guilty on all charges except for the illegal possession of the firearm. We will see how everything plays out. I might do a post recap video of the Kyle Rittenhouse trial. All right, please like, subscribe, comment, and share these videos. I will interact with you if you leave a comment. I will appreciate it if you like it, and I truly need the subscription. So thank you, everybody, for tuning in. Joe Pometto, Joe the lawyer, out. We will see what happens in the coming days as far as the verdict is concerned. I don't think the jury will deliberate that long, though I don't think it'll be like that. I give them a day and a half. All right, everybody. Thank you very much. Bye-bye.